afternoon. This is a reconvening of the Special Committee on Criminal Justice Reform. With me on the panel, I see just came in, Kara Bradford Gray. We have Tariq Shabazz. We have Reverend Marvina. We have William Cobb. We have Judge Lerner. We have Ann Schwartzman. We have Julie Wertheimer. We have Rafael Rojas. And we also are joined by Richard McSorley. We do have a quorum, so we can begin our business. I just want to thank everybody on this commission for their time, their talent, their interest in criminal justice reform, and say that the process is better off because of it. And that's a sincere thanks. And I want everybody that might be out there watching this to understand this was not a monolithic committee. We all have different life experiences, different professional experience, different views of the world, but we came together for the better and greater good. And for that, I am truly thankful for it, your time, your talent, and unfortunately, none of your treasury. So we are going to convene. Will the clerk please read the title of the resolution?
Resolution number 160101, a resolution appointing members to the Special Committee on Criminal Justice Reform who will conduct public hearings examining the Philadelphia criminal justice system for the impact of current policies and offer recommended strategies for reform that are in the best interest of public safety and the public good.
Thank you, Ms. Williams. The purpose of today's hearing is to review recommendations that the Special Committee will put forth to all of City Council this Thursday at their next session, November 17th, 2016. These recommendations are based on hearings and field trips and information and testimony that was submitted concerning pretrial reform, which occurred on August 1st and September 12th. These recommendations will be presented today by all members of our planning group who worked hard on reviewing all of this committee's transcripts and notes and reports that we were able to gather in order to comprise this interim report that we are submitting today. Before I begin, I would like to offer my fellow committee members the opportunity to say something at this juncture if you choose. Okay. Co-Chair Gray.
Thank you, Councilman Jones. And I want to thank the work that you and Samantha have put in on this committee as well in helping us get organized as we prepare for true criminal justice reform measures. I really appreciate the opportunity to explore our use of pretrial bail. I think that there's a movement across the nation to enhance pretrial service delivery, and it includes finding alternatives to incarceration during pretrial visits. One, as it is costly and it is not an effective means to achieve public safety. I think the recommendations put forward in this report do reflect those best practices around the country, especially with the DC model. I know that Philadelphia has to understand how they're going to fund a lot of these initiatives, but I really, really believe that if a concerted effort is put forth, we can start to pilot things and bring them to scale once we understand the impact of those pilot programs. So I am really proud of the work that we did in here. While I know we still have ways to go, I think that we're starting on a nice infrastructure to deliver our criminal justice practices in a more sensible way and one that makes better use of taxpayer dollars.
I want to thank you personally also. I think without fear of successful contradiction, you've coined a new phrase. We know what reentry is, but now you've said it over and over, pre-entry. And I think that's going to become a part of our jargon, at least in these chambers, for some time to come, and we thank you for that. Will the clerk please provide the names of witnesses who will be testifying today?
The first witnesses will be Richard McSorley and Michael Bouchard, who will testify to the first two recommendations contained in the interim report.
Would you please approach, wait a minute, Okay. So you're on that side of the table today? Will you please approach the witness table, have a seat, bringing the mics close to you, and then state your name for the record. And begin your testimony.
Good morning, Councilman
This
Jones.
afternoon.
Oh, this afternoon, distinguished panel. See, when you work like I do, it's just one big blur all day long.
Got it.
My name is Richard McSorley. I'm the Deputy Court Administrator for the Court of Common Pleas Criminal Trial Division.
Good afternoon. My name is Mike Bouchard. I'm the Director of Pretrial Services for the 1st Judicial District.
I am a member of the committee, which is why I'm doing the presentment today. But because I have been around long enough to know what I don't know, I brought the Director of Pretrial Services, Michael Bouchard, who most of my presentation for this initiative has been based on information that he's provided. So we're going to be discussing very briefly the first two recommendations that the city should acquire more electronic monitoring units for use as an alternative for pretrial incarceration, and also that the city should increase funding for additional pretrial services staff, which is necessary to provide greater services to individuals who will be released while awaiting trial. And we're just talking about the pretrial release staff, not post-trial release. So that said, I will turn it over to Michael to briefly go over the highlights of what these recommendations are.
Thank you very much.
So as Mr. McSorley said, our first recommendation is that the city should acquire more electronic monitoring units for use as alternative to pretrial incarceration. Our current system is very outdated and needs to be replaced. We need more EM units as well. Adding these units will allow us to decrease the length of stay for people who are going to be placed on electronic monitoring. They spend less time in jail. And those who were previously ineligible will now be able to be released due to the technological updates that the new system can provide. The EM conversion also includes a new server, a redundant server at a geographically separate location, appropriately configured computers, wireless electronic monitoring units, updated landline units, annual software, technical support, and licensing as well. We'll be increasing our number of units with this transition by about 22%. A lot of this is, several of these items are being funded by the MacArthur grant, but additional resources are needed on an annual basis beyond what the grant will allow us to do. That includes the annual subscription to the cellular service is required at approximate cost of $166,075 a year. And also to maintain the 100 landline units, the annual maintenance fee is approximately $8,500 a year. Also, 2 additional staff members would be needed within the electronic monitoring field team of pretrial services to assist in the transition of these units and the maintenance of these units in the field, which is approximately $64,892 for their total salaries. Second recommendation is the city should increase funding for additional pretrial services staff, which is necessary to provide the greater services to individuals who will be released awaiting trial. As we know, cash bail remains a significant factor in a number of cases, with 60% of individuals being arraigned receiving cash bail in Philadelphia. Our current pretrial staff is not robust enough to supervise the predicted number of individuals that will be released from the prison, so we need to increase those numbers in order to properly supervise those individuals in the community. Again, part of this transition is being funded by MacArthur, but again, we require additional staffing resources that exceed the resources available through the MacArthur grant. Additional range of conditions will be included, including through supervision, including but not limited to release on recognizance, court reminders, remote and in-person reporting, and electronic monitoring. All of this is the goal to reduce the unnecessary pretrial incarceration while maintaining public safety and decreasing the number of people who spend time in jail awaiting trial. The goal is to reduce damaging collateral consequences of incarcerated and future recidivism. The additional funding required include 7 pretrial officers whose salaries are $37,428 per officer, which is a total of $261,996 a year. And again, the EM field team would also be part of that, staffing as cited before at $64,892.
I'd just like to make 2 clarifications for the committee, and it's something that we hear a lot The first one is on EM. We get asked, why aren't we just expanding or adding GPS and wireless to our existing EM abilities? And it's because our EM abilities right now hover around 600 plus bracelets that are all landline. And I think anybody who has been around anywhere in the last 5 years knows that landlines and that technology, most people don't even have them in their house anymore. So they're on their way out to begin with. We have to prepare for that inevitability. And it's just technology that for us, not only is burdensome, takes more time, there's more maintenance, but for the defendant themselves, getting them on that system takes longer to be released on an EM when it's a landline base because of things that Verizon has to do with the person's house, and wireless and GPS will be a much, much faster from the time it's ordered by the court to the time of release. We're hoping to knock that down to 1 day eventually. And the other clarification, just as Michael just spoke, is that we realize that around 60% of the people that go through the arrest to arraignment process might have bail set, but only about 23% of those people are actually held incarcerated on bail only. The other percentage are people that have other kinds of detainers, which we've talked about in this committee many, many times. However, they still are part of this population for us, because if somebody has a detainer or a bench warrant and bail, and they resolve the detainer or the bench warrant, and they're then able to post bail, they would then become that pretrial release. And it might be another incentive for the court to say, I'm going to lift this detainer because I know that this defendant will post bail and we can put him on EM, so I feel more comfortable lifting the detainer for a future date or until future cases are disposed of. So I just wanted to make those quick clarifications for the committee.
If I could, so I was remiss in not saying that the purpose of all of these considerations, one goal anyway, is to reform, and reform means also reducing the number of people generally that are held on state road for nonviolent offenses, and to figure out non-economic ways to dispense justice. That is a overarching goal. EM monitors, electronic monitors, are one arrow in the quiver of things we can do practically. Many people have referred to it as very low-hanging fruit, but very effective fruit for this. So, with that said, describe for me again the old technology and how many units we actually had.
On any given day, the active number of units varies. So I've seen it, and I've been in this position for about a year and a half, and I've seen it as low as 520 and as high as 620. So it ranges. We do have enough units to manage those numbers. The technology uses old copper analog phone lines. So Verizon's going out to these homes and having to run special lines. No features, no call waiting, no caller ID, nothing can be on the line, or the equipment doesn't function as it should. Back to what Mr. McSorley said is, Verizon is slowly doing away with those. And there is a small area in the city where they have basically told us we are no longer doing this. And they said, just so you know, this is coming. Eventually, we're going to be eliminating it all across the board. So
we're dealing with a antiquated technology anyway for those 500 to 600 units that are available.
Yes, sir.
Secondly, so when we say we should move to this new technology, it is internet-based, and what other technological aspects should we know about?
Well,
and what are the limitations of those technologies?
I think that it's important to discuss everything that it will do. So currently, what we'll get is a server and a redundant server. Currently, we don't have a redundant server. I think that's critical to put that in place. The software that we're going to be utilizing is internet-based. It's going to give the actual officers who supervise these cases more hands-on abilities compared to, without getting into the details, we have a monitoring room who does a lot of 24/7 monitoring of all the defendants. They have much more access currently with this system than the officers have. The officers are going to be able to pull it right up on their computer at their workstation, any information they need on the given defendants. It's going to be able to house wireless updated landline. If in the future we move into GPS, the server is also going to be able to maintain GPS units as well.
So with this technology, in a lightning storm and the power goes out, what happens?
There are several different things in place. If the power goes out, most of the equipment has battery backups that will last X number of hours. Generally, that hasn't been a problem. I've not seen a case yet where the power's gone out and we weren't able to still have monitoring occurring. The transmitters as well have backup batteries where alerts will come in 2 to 3 days ahead of time that the battery's low, so they'll still be functioning until they can make their way into the office to have that changed.
I'll add to that, being slightly older than Michael, I'm not as tech savvy, and the one thing I've noticed,
We drew that when you kept referring to him on technology. We figured that one out.
is that the landline, the bottom line with the landline system, that our own old phones we have, if there's a problem with the phone line, you need somebody to come out and fix the phone line. It's not easy to do. With this technology, like your cell phone, if you have a problem with your cell phone, it's easy to swap out, replace. It's usually very, very fixable. And the other thing I've noticed in being in negotiations with the vendor that the FJD is picking for these new EM bracelets is that it appears, and we have this, always think about this when we're writing these contracts now, is that when those upgrades come out, when need to use the analogy, the iPhone 7 or 10 or whatever's going to be the next Samsung.
You just sound techie to me. Go ahead.
I can sound it. But when that happens, we can easily upgrade our systems to follow the technology. Whereas today, if all of a sudden, as I said, there's a landline upgrade, which there never will be, we couldn't do anything about it.
So it's like when you upgrade from an iPhone 6 to a 7, you'll be able to do that. And who absorbs that cost?
Right now, it's part of the MacArthur initiative to get it started, but it will be the First Judicial District. It's our contract with the vendor.
How many units are you recommending this committee endorse to council? How many units?
What the total will be with
Yes,
MacArthur
total.
plus these recommendations will be 700 wireless units and 100 landline units. So 800 total units.
800 total units, up from 600. Okay. When someone violates the terms and conditions of their GPS house arrest, what happens?
Okay, just to be clear, we do not have GPS yet.
Oh, wait, okay.
But
whatever, the technology.
essentially, to simplify the process, an alert comes into our monitoring room. The staff will investigate the alert, whether it's a phone call or troubleshooting the technology, determine what needs to happen next, try to make contact with the defendant, and if it's deemed a true alert and a true violation, then a warrant is drafted and sent to the sheriffs for execution.
So, did we used to have a warrant unit that would instantly respond to these kinds of violations?
We did and still do. We had a court pretrial warrant unit that is now the sheriff's warrant unit.
Okay, so...
it's still a 24/7 warrant.
It's still in existence. And is that a rapid response, or let me call you Tuesday when it happens?
They have the ability to go out 24/7. We have it so that they can go into our common police case management system, print out a warrant with the judge's signature at 3 o'clock in the morning on a holiday weekend, and they can execute that warrant as soon as they can get to the house.
Chair recognizes Ms. Gray.
Thank you. Rich, I just wanted to add comment on your discussion in terms of the landline use. We just had a few people that the judge made house arrest option available to them, but they did not have landlines, and the feedback I got from them after the discussion with Verizon is that Verizon could not get out to install one for 4 to 6 weeks. So even though they're eligible and have been deemed not to be a danger to the community, and they would practically come back to court, they are still sitting in jail for at least 4 to 6 weeks, incurring costs daily. So I do agree with you on how the technology stifles the movement of people in pretrial status. Secondly, I wanted to ask you, and while we are focusing on reducing our population and utilizing monitoring systems, will the court entertain opportunities to make referrals to appropriate treatment options for those who have more of those public health issues coming into our justice system. For example, the drug users
Right.
and, people with mental health issues.
I'm going to turn that over to Michael because that goes to the pretrial resources.
Right, what we do now is if seems to be an issue that needs to be addressed, our pretrial officers have a range of community options that they pass on to the defendants. I think that there needs to be more. I think everybody will agree that there needs to be more than that. And that's part of pretrial's growth. And part of the MacArthur grant in year 2 is going to include working on a needs assessment at the pretrial level and also bringing in a social worker, one to start, to really develop that in a more efficient way.
And will this be a part of any kind of pretrial conditions, or will we make it as, it's a voluntary condition that may go a long way in your case outcome, but if you do not do it, you will not be taken off the street and be put into prison for it. However, we would encourage people, all partners in the system, the Defender Association, I'm sure the district attorney, as well as the courts, to engage in this level of services because it could have some significant impact in their outcomes where they're on the right path and they may not have to be jailed at any point if they're beginning to do what they're supposed to on the pre-entry side.
I believe the way it's going to work out is just as you said. Right now, as it is, it's voluntary. We encourage, we explain how this will benefit you. I know that your office explains to the client, hey, if you can tell the court that you've been doing all this work before going to court, it's only going to benefit you. As it being a condition, I don't think we're in that place yet to make it a condition. If we get to that place, that'll be a conversation we would have with our judicial leadership and decide, do we want to make this a condition that could be a violation, or do we just want to make it a condition, and if it's not followed, that'll be up for the court at a later time to deal with.
And additionally, I think it's really important to, when we are doing this and bringing forth services, as everybody's aware, I think it's extremely important to remember that giving too many rules, regulations, can lead to further recidivism, penetrating the system even more. And I think as we move into those resources, making sure that we're choosing the appropriate population to receive those services is in the best interest of everybody.
Tariq?
I'm a little concerned about that last answer because I do understand and would even acknowledge that too many rules it's been demonstrated over the course of time that too many rules can in fact put us in the same situation that we're in. That is, people violating and people being incarcerated on crimes that pre-trial, on crimes in which they are nonviolent and they may be able to be back into their communities. But at the same time, what we have to have is some type of incentive. Now, one of the problems that we always run into when we talk about substance abuse is someone's desire to get clean, for example, or someone's desire to seek help. If we're offering the help, and as part of the incentive, if you will, for an individual to take this help and that will release them from jail, what is it that we're having as a result of, or what do we have at our disposal based on the recommendations, that if that person says I'm going to do it and then gets out and doesn't do it but continues to abuse drugs, for example, and that continuation of abusing drugs may create other issues. What do we have at our disposal as you see it right now to deal with that aspect with regard to electronic monitoring?
I think right now we don't have a whole lot to deal with that situation. If we have somebody who's out on pretrial, we cannot make it a condition to attend NA or AA or to go into rehab or treatment. We can strongly suggest the court can finally do that when they put them into a treatment court program or something like that. If we get the resources down the road and we say we're now going to make this condition, we then have to not only deal with what Mr. Bouchard said about over-supervision, but we have to deal with the fact that this is a pre-trial case, and this person has not been found guilty of anything, so the carrot and the stick is more difficult to say to them, you can be released if you get treatment when it hasn't been determined yet, really, essentially, if they need treatment. So it's going to be something that has to be worked out with all the justice partners. But to answer your question, right now, if someone is arrested for a narcotics case and it's obvious the person needs treatment, and they go back out and abuse their drugs again, most likely they're going to get arrested because of their addiction, and we don't have anything in place to help that person avoid that situation until their court date. We just don't have the resources.
The concern I have is that some of the petty offenses that we talk about are the result of addiction, are the result of alcoholism, is the result of sometimes even mental health issues. If in fact we're not addressing that issue, we're just using this as a term of letting someone out of being incarcerated and they're still not getting the services, do you see it seems to me as in the terms of Malcolm, a vicious cycle,
Yes.
that we're just going to be repeating that. But I did hear, and I would like to suggest that inclusive in this presentation is that resources are needed. So that if those resources are needed, and we do have to have some type of supervision, and we do have to have some type of consequences, we can strongly encourage, how about that one?
Yes.
Strongly encourage, is that a new phrase that I can use? Strongly encourage people to actually seek that type of treatment. It just seems to me defeating the purpose of saying, okay, we're going to use this, we don't want to hold these people in because we don't want the prison population to grow financially to the end of it. All of things I agree with. I'm on this committee for a reason, I agree with that. But we're not dealing with the root issue. Are we creating a vicious cycle, or are we really taking care of anything?
I think you're absolutely correct, and I think I can say for one of the few times of my career that the point of the district attorney, the defender, and the courts is all the same. We all agree this is a vicious cycle, and we don't have the resources to address it in the way we would all like to. The DA's office doesn't want to have to prosecute somebody because of their addiction. The defender doesn't want to have to defend them because of it, and the courts don't want them to have a criminal record and go to court because of it. So if we can find an alternative way to address it, we're all on board.
So we're going to go to Judge Lerner first, and then we're going to go down the other end.
I assure you, it's just a coincidence that the ex-judge gets to speak on a subject after hearing from the chief defender and the soon-to-be first deputy district attorney take opposite positions on that subject. I think we are at a really critical point in our discussion of several of the recommendations here. First of all, we would waste a huge opportunity under MacArthur and just under our general ideas of criminal justice reform were we not to really embrace fully recommendation number 4 here, which talks about what we've just been talking about, and that is using the additional information about defendants and their needs, not only to avoid pretrial incarceration, but to make the earliest possible determination of what type of treatment and rehabilitative programs those defendants could benefit from, and then to take the next step, and that is to make those programs available as early as possible in the process. Not simply as early as possible in the life of the criminal case, but as Mr. El-Shabazz says, as early as possible in the life of the defendant. We have the bare bones of being able to do that already in the MacArthur grant. The defenders' bail advocates are going to be in a much better position to learn a lot more about the defendant's life and the defendant's issues and the defendant's needs, and present that to the initial bail setting authority, and if that doesn't work, present it to a judge of the municipal court at the early bail review. So we're going to have a lot more information about rehabilitative needs earlier in the process than we have now. Also, if we go to the expense and the trouble, which I think we should, of setting up day reporting centers, it would be a terrible waste not to have those day reporting centers equipped with people who were able to steer defendants to rehabilitative and treatment programs that it was already determined they would benefit from. Whether or not we could expand those day reporting centers into treatment centers also and have the treatment, at least for some things, available, and the treatment providers available at those centers, that's another step forward, which I hope at some point we'll be able to take. So in terms of what we all agree on, I think that's what we all agree on. What we don't necessarily all agree on is the issue framed by Keir and by Tariq. And I want to speak for a moment on that. There's nothing in the law that I am aware of that prevents a bail-setting authority from requiring, as a condition of bail, as a condition of release, pre-trial, that a defendant takes certain steps which the bail-setting authority has determined will improve both the likelihood that the defendant will appear and the likelihood that the defendant will not present a risk of further law-breaking to the community. As long as those steps don't interfere with the presumption of innocence or the defendant's right to have a complete and full trial at which he or she is going to assert his innocence, there's nothing in the Constitution or the rules of procedure in Pennsylvania or in the statutory law that prevents us from developing a system where reasonable requirements with regard to treatment and rehabilitation cannot be imposed as a condition of pretrial release. And in my judgment, although the devil's in the details, and we really got to be careful not to intrude on somebody's right to a full trial and their presumption of innocence, we would make a mistake, a big mistake, if we didn't take the advantage that we have of coupling these two things together.
Well said, Your Honor. I guess the court has ruled on you two.
Yeah, I need to be enlightened. I have two questions. Number one, if someone, the inmates that we met with at the House of Correction, many of them had state-issued detainers. What is going to be the interfacing of the state detainer and the supervision, which usually comes from a state parole officer, and people that are going to be, first of all, how are you going to get them a pretrial if they have a state detainer?
Well, the state detainer has to be resolved before they can get into that pretrial population, and as we discussed when we were up there, that is an issue with the state probation and parole department, and when they contact us, I can tell you from personal experience doing the actual scheduling of these cases, when a state probation officer contacted me when I was in criminal listings, I got that case scheduled in front of the judge right away. Now, what will happen with that state detainer if there's open cases, if there's other matters, it is a complex situation. I would say that for this discussion, for the population that we're going to be addressing, those people with state detainers are not going to be easily added to that to our population right now, currently. It takes a lot of work to get the state detainers resolved. And in fact, if it's a state detainer, there's always that chance that the person's going to wind up doing back time anyway. So you don't want to go through all this work to get the state detainer addressed, get bail set, and get him released, only to find out that the back judge is going to sentence him to additional incarceration.
Do we have the figures on the people that would be eligible who don't have a state detainer?
The people who are currently incarcerated who do not have state detainers who would be eligible for EM release?
Right.
Do we have? I mean, I can tell you what we're doing right now.
The range of population, are you referring to people pretrial only?
That don't have the state detainer, so you don't have to go through the...
And don't have county detainers.
Right.
With
County.
with county detainers, with the MacArthur grant in the second year, we begin addressing that population.
I'm sorry, I don't mean to interrupt, but for those listening, can we elaborate a little bit on detainers and causes of them and difference between local and state?
Okay.
Just,
A detainer as opposed to a bench warrant. Detainer is a violation of probation where the defendant is on probation, whether a state sentence was imposed on the defendant or a county sentence was imposed on the defendant. He's on probation, he has certain rules and regulations, he has to come in and report, he has to get his GED. As we were just discussing, there's all kinds of conditions for probation. When a violation occurs, there's two kinds of violations, direct and technical. Direct violation is if the defendant goes out and gets a new arrest. It's kind of like one of the conditions of probation is that you don't go out and get a new arrest. That's a direct violation. Technical is if he's failed to do something. He has hot urines or dirty urines, whatever you want to call them, but he comes up positive for use of narcotics in his urine. He's not reporting, he's an absconder, things like that will become a technical violation. When the person is violated, a determination is made whether to incarcerate the defendant when we catch up with him, and that's who we're talking about, those people that are incarcerated. So again, it just shows the complexity. If it's a state detainer, it's one entity has to be contacted and addressed. The state people have to be involved. If it's a county detainer, it's Philadelphia County's people who has to be involved. The case has to be scheduled before a judge. It has to have a review hearing called a Gagnon 1, then a Gagnon 2. So the bottom line is as long as...
You can't use jargon. You have to explain.
Well, everybody's entitled to a violation review. And from the time of incarceration, you have to have that first initial review within 10 days. After that time, if it's determined that it is a good hold, you have to be in front of your judge, your sentencing judge or a judge, within 21 or 22 days after that 10-day period. Right now, that process in Philadelphia runs very well. We've worked very hard with the Defenders Association, with probation and parole, to make sure that when someone's incarcerated, the court knows almost the next working day. We're getting it scheduled for the first review timely. We're getting it scheduled for the second review timely. The issue becomes when the person has a detainer, they shouldn't set bail. We won't accept bail for the most part because they won't be getting out. We don't want them to put money in our coffers when it's a chance that they won't get out, because when that person sees the judge could say, okay, it's minor, probation continued, detainer lifted, no more hold. The judge could say, this is major, I want to review it, I'm going to continue this case. The judge could say, this is bad, I'm going to give you your back time now, and I'm sentencing you now, you're off probation to the rest of your time. So we don't know what's going to happen until that hearing. So that's why these detainers are complex.
So the differences can be hours, weeks, or months, depending on where those are of a stay of a person on state road. And that's why we have to get it right.
I guess my other question is, Philadelphia is a sanctuary city. If someone who is not documented gets arrested, are they going to be processed for house arrest, even though they might be undocumented?
If they have no detainer hold on them and they are a pretrial eligible person, we're not going to look into the fact of what their standing is. If they have a house, we can verify it, we can set up the monitoring. That's part of the sanctuary city issue, doesn't play into the pretrial decision. It's a defendant, he's got their household, they have posted they can't post their bail, they have no other holds on them, there's no immigration detainer on them, we will accept them into the EM program. As soon as there's a detainer on them, whether it's from ICE or from somebody else, they're not eligible for the EM violation or unit.
It's important to understand in response to that question that ICE or federal detainers with regard to immigration is different than things that are occurring in the county, so that the county level or state level is one jurisdiction. The federal jurisdiction, for those that's listening, is a different jurisdiction. So even with the city being a sanctuary city, and with new administration coming in January, if in fact there is a follow-through on the promises, I'm being very selective in my words, that the president-elect has indicated, his look is going to be at those individuals that he consider criminal element or committed a crime to the end of it. There may be a federal immigration detainer in which, whether or not we do anything in this chambers or anything in this county, would not be able to even deal with that regard, because federal jurisdiction is different. So I just wanted to kind of clarify that this is a sanctuary city. I think basically what we're saying is, as a county, we're not going to look to lodge a detainer with regard to an illegal alien or someone that is in that category, as indicated clearly by the president-elect. However, federally, there is different jurisdiction, and oftentimes you may have a detainer that isn't listed with respect to someone regarding city or even commonwealth or state, but may be listed in terms of federally, as it relates to immigration status.
Are you?
Yeah.
You're done?
I'm done.
Okay. So what is the, if this committee goes with these recommendations and it is approved by council and it is adopted by the city in its budget process, what will be the net impact, in your opinion, on the census on State Road?
I think the net impact on the census on State Road will be a positive impact, that we'll be able to get more people who are qualified for EM out of the prison faster than we can do it now.
So give me a sense of scale.
I don't have the numbers in front of me, but the MacArthur team broke down each initiative that we are looking to roll out over the next 2 to 3 years. And in that report, and I'm not sure if you were privy to that report, but it is out there. I'm not sure if it's broken down by what our estimates are that each initiative will reduce the prison population by.
Give me a ballpark.
I mean, our overall goal is 34%.
You're not
So-
under oath, so 34%
From
of the 75?
8082,
Okay.
which
Okay,
was our
80, 82.
benchmark in July of 2015 when this project started.
Got it. Are there any other questions for these panelists?
Is this all just for adults or minors included?
Got to say your name for the record,
Rev-
so that
Rev-
the stenographer...
Reverend Adan Mairena from West Kensington Ministry. Is this just for adults or including
Just
minors?
adults, yes. We're only talking about the adult system. The juvenile system is a separate system, who has their own EM unit, their own probation, they have GPS in juvenile, by the way.
Any other questions?
I just have one
Chairman
comment,
Gray.
and I think I take the words of Tariq and Judge Lerner to heart when we say we're going to be missing an opportunity if we don't service it. I think this is a time where we can get more creative in bringing in those organizations that already treat individuals for certain addiction problems or mental health issues. We have those resources available to us. It's just joining them together now in this effort to focus on a population where we are looking at and understanding that putting them in jail is not solving their addiction or mental health issues anyway. So we're spending money needlessly when we can be utilizing it in a much meaningful way with the people who were trained to deal with this properly. My whole thing is that the criminal justice system can't deal with every issue, and it shouldn't be used as such. We should deal with the issues that it was meant to and designed to deal with, which is the true threat to public safety by threats of violence or whatever it is that will rob people of their security. But when we're dealing with it on a net widening type of fashion that we have done, we are not seeing the return on our investment. So I will echo the sentiments of Tariq El-Shabazz that we need to take advantage of this opportunity, but we do not want to we want to make sure, because we don't talk about this a lot, and I don't even know if it's a real reality. There is a presumption of innocence, and so everyone that comes into our system is not guilty. And we need to make sure that we don't put unnecessary conditions that we will penalize them for. But we can utilize these, when people do take the opportunity to get the help they need, they still have to come for a final disposition. And all of that information of what they were doing and what they have done will be used in a way for us to find a better, I guess, final disposition for them. I mean, so there is a carrot at the end of it. If people want to take advantage of it and they do, you come in front of Judge Lerner or people like him or used to be like him and present all the things that they have been doing pre-trial. And that may really decide whether or not they need to stay in this system or just continue doing what you're doing. So I think that we'll have that ability.
I think that's well said, and basically what I was going to
Say
add.
your name for the record.
But I did want to mention, too,
You have to
that...
say your name for the record.
I'm sorry.
Stenographer.
Ann Schwartzman, Pennsylvania
go.
Prison Society. I did want to mention that these two recommendations will also help cut back on the consequences of incarceration for people that end up spending time inside, especially if they're innocent, but also the impact that that has on their families. Because when people lose their homes, when they lose their apartments, when they lose their jobs, we're basically ensuring that that cycle of incarceration or being in trouble or being involved in the criminal justice system will continue, instead of looking at ways to provide the resources and the treatment and the different stipulations that can help people have better lives. So I think this is incredibly important, and I'm glad we're talking about it.
Well said. Are there any other questions germane to this issue? Seeing none, thank you for your work. Thank you for your testimony.
Thank you for
Thank
the
you, sir.
opportunity, Council.
Will the clerk please read the next witness to testify?
The next witnesses to testify on recommendations number 3 and 4 will be Keir Bradford Gray, Julie Wertheimer, and Tariq El-Shabazz.
So does that mean they have to go sit over there? Yeah, I think that's what, you're on the other side of the table now.
You seem like you got a problem with that, sir.
Yeah, I don't want you to leave me.
You might want to separate us.
So, I'm going to put you up for a talk show or something like that, point counterpoint. We'll use Judge.
So that the record is clear, this is a very close friend of mine, just so that you know.
You can have different opinions.
The fact
and
that
be
we disagree
friends.
doesn't mean that we're not very
that's
close.
right. We'll have Judge Lerner as the referee.
I'm just delighted to see the two of them in the position that I'm accustomed to seeing the defense lawyer and the DA in. But Julie, I don't know how you're
She can stop
Hey,
us.
Julie, are you okay?
You know, you're such good friends, you better be ready to duck.
So will the witnesses testify, state your name for the record, and begin your testimony, please?
Keir Bradford Gray, Chief Defender of the Defender Association of Philadelphia. I will let Julie go first because hers kind of opens the door to some of the other information that we
That's
will bring
fine.
out.
Ms. Wertheimer?
Julie Wertheimer, Chief of Staff to the Deputy Managing Director for Criminal Justice.
Pull it closer to you.
Tariq Kareem El-Shabazz, I am the Deputy Special Investigations for the Philadelphia District Attorney's Office.
Thank you all for your services and work. Ms. Wertheimer, would you begin your testimony, please?
Sure. One of the recommendations put forth in this report is that the city should develop a tool to be used in bail determinations with the goal of reducing our reliance on monetary bail being assigned especially to nonviolent or low-level offenders. The First Judicial District plans to work with researchers at the University of Pennsylvania to construct a pretrial tool designed specifically for Philadelphia using its historical data rather than the off-the-shelf tools that a number of other jurisdictions have adopted. However, since the tool has not yet been designed, specifics about the tool and the factors that it will consider are currently unavailable. I think it's important to note that during the hearings we heard from a number of different perspectives about the challenges and opportunities that come with a risk tool and the question of bias and how it may or may not reduce or perpetuate bias in the criminal justice system. One of the major factors of concern is zip code as well as race or ethnicity. Okay. But there are other factors that were discussed as well. I I think it's important to note that while Dr. Richard Burke, who is the researcher at Penn that testified before the committee and also is the one that the First Judicial District intends to contract with to develop the tool, he suggested that it's up to the jurisdiction about which factors can be used. And while he made some comments that it said it would likely sacrifice the accuracy, I think it's important to note that there could be some accuracy sacrifice, but we really don't know until the tool is developed and run. And it's also important to note that national researchers and academics have said that well-developed risk tools can reduce bias. It cannot erase bias entirely, but it does add some level of parity as the tools consider the same factors as bail magistrates do, but do so in a more systemic, even fashion. Take over from here.
So my part really picks up on that. I think as a committee, and I'm talking about the MacArthur Committee, we did agree that some form of a risk assessment tool may be utilized in this quest for balance, so we can have some uniformity in the way we're making decisions. But I do want to caution this committee that what we are doing today is really trying to eliminate the inherent disproportionality. I do understand that the criminal justice system has its largest impact on low-income communities of color. However, that does not mean that we should design a tool that has those baked-in biases within them. And we can do, because we have a lot of practitioners on this panel and a lot of people that understand people and neighborhoods and policing strategies and communities, we can use that knowledge to make sure that what we develop as a tool and what the researcher suggests has included an understanding of the way Philadelphia City works in terms of policing. So let me give you an example of what I'm talking about. Some of the information that we have discussed with other risk assessment tools include arrest, not convictions, but just arrests. Arrests have nothing to do with your future ability to with someone's ability to commit a future crime because of the inherent way it's based on police practicing. Someone could be arrested 3, 4, or 5 times and never get a conviction. That should not be used against them in terms of predicting this person's risk level. There should be a lot of other factors that we turn to, and maybe we should get rid of the fact that we use arrests alone, arrest in that context, is to give it a score of some sort. Yes, it can go into a determination, but putting it in a risk assessment tool will provide disproportionate outcomes for people who do not get arrested or policed as heavily as those in the inner cities. So I just want to make sure that we understand, we can all throw out zip codes. Yes, that's glaring, right? What zip code you live in, that's very glaring. But other things such as using arrests, to us, sounds reasonable, right? But then you start examining how are arrests developed in certain sections of the city? How are they racked up by people, and how often do those arrests result in convictions? Those are the things that we need to be mindful of, because I think what we are tasked to do is to provide fundamental fairness within our justice system, and fundamental fairness does speak to the inherent bias of our practices and our policies in this system. So if I do nothing more than advocate for making sure that fundamental fairness is within this, that's what I will contribute to this, because I think that that's very important, and we see the disproportionality play out in the way we deal with drug usage. I mean, the heroin opioid epidemic has been designed to treat drug use as a public health issue. Many counties are formulating task force where those individuals are not even arrested. And so when we look at the practices in the inner city where people are still arrested in record numbers for drug use only, we see the way our system treats different people based on where they live or what communities they come from. So I'm just saying that while the researcher told us as a committee that the tool can be as, however we want it, most people do accept the analysis of the researcher because of the researcher's level of knowledge and understanding about these algorithms and the things that go into this tool. So I would call on us as a committee to question and come up with some guidelines as to what we would want to be mindful of in this risk assessment tool and putting this risk assessment tool together, and therefore have him develop one with those things in mind, if that makes much sense. Hopefully it does.
Tariq?
Well, that was recommendation 3. I don't know if you want to move on to recommendation.
No, we don't, no. I think we should deal with them, in my opinion, separately. I'll recognize you in a sec. How accurate, well, first, where were they developed for people who are listening? And I have a sense of that. And how accurate, and you can respond to this as well because of your vast experience in dealing with it. When you look at that form and it says somebody is this risky, whatever that is, how accurate is it of a tool currently, and how accurately do you predict? How can we get it right?
That's the question, right? How do you predict accuracy? And I think what has happened in jurisdictions that we've seen, especially in DC, the only way they predict accuracy is, I think, I forget what they call it, but every so often, every few years, they measure it. They understand, what did it do? Did it really do what it was designed to do? And that has to be a review period over a certain period of time. Once we see how many people we brought in and how many people we predicted certain things about, whether or not those things were actually accurate would only come with time. So you would have to build in a way for a review committee to understand the impact of that tool. So these are things that are not set in stone. We don't know the answer to a lot of them. And so when someone or when a researcher tells us that if we do this, it will decrease our accuracy, how do we know that? You cannot predict human behavior. You can only study its patterns.
I just want to ask, is it more accurate than my horoscope? Because
Actually,
I say it as a joke, but I say it in true. How over time, how accurate have these
the problem that we
measurements
have is that you're asking about accuracy at the same time we're asking about somebody's constitutional right and their presumption of innocence. The fact that someone was arrested for a crime, they were never convicted of it, doesn't in fact put a veil on them as if they are more apt than not or more available than not to participate in criminal activity. That's a difference. That's the distinction between it. So what we're trying to stay away from, and I agree in part with what Keir is saying, and I disagree in other part to what she's saying, and that is that we can't begin to use as a risk assessment tool arrest and give it certain value over other things. But to neglect it, to ignore it, and not to consider it at all is just as much a vital mistake. What we have to do when we're looking at it, I would submit to you, and we're viewing it, we have to view the surroundings in which it occurred. For example, we can go to particular maps, and I know that the defenders have this within their study, where people are arrested for particular activities more in particular jurisdictions. Certain districts,
justice
people
by
are
zip
arrested.
code? That's what I want to.
But it is, and it is and it isn't.
Right.
It is. On a particular block, an officer may know an individual. That individual may have 5 arrests from that particular officer. There are 2 questions that you can get. One question is, this guy just hasn't learned his lesson and he's still out there, or this officer had identified this individual for whatever reason and is arresting him over and over again. If in fact we use the 5 arrests, and let's use that as an example, of just occurring with a particular officer in a particular jurisdiction, it makes the person seem more apt to commit a crime because they were arrested 5 times, however, never convicted. But if we use it as a tool in conjunction with other things, if I see that, let me look at the area in which it occurred, and I can assure you that the Defenders Association would have at their disposal that in this area, this many people would be arrested, and by this particular unit, this particular tour or duty, this particular police officer. Because sometimes you have an officer, you have somebody who's arrested somebody 6 times, the same officer. So you need to look at that. But to ignore it altogether is a problem. So what I've just said to you is, in answer to how accurate it is just as accurate as your horoscope. We don't know. It's a tool. It is something that we should look at and we should consider. So in considering it and looking at it, the question becomes how much weight to give it. Do we give it more weight than other activity? For example, the person works. He's never missed a day at work. Person doesn't have any drug addiction or any alcohol addiction or any other problems. This person comes from a community that people are speaking up for him. The person has a family and his family seems intact. But he's had 7 arrests. No convictions, 7 arrests, while he maintained those other 4 things. You balance that, because that may indicate that this person, there's some other underlying issue that exists between this person's 7 arrests. Just compose that with an individual that was arrested 7 times, unemployed, family background may be problematic, may have a drug addiction, may have other issues. His risk assessment may be different. Does that mean you put him in jail? That's not what I'm saying, before anybody jumps off a roof. But what I am saying is, that is information that we take together. It's kind of like making gumbo. And I'm not a gumbo eater, but I seem to recall that in New Orleans, depending on the gumbo, is always the secret ingredient that people put in. In other words, they put everything in. And then a person that has real good gumbo may put something a little different than the other 10 people that make gumbo. But at the end of the day, you have the soup with different ingredients. What I'm indicating is that we look at all of the ingredients. We take them into consideration. We don't give more weight to an arrest because I think constitutionally that is a violation. It's an arrest, it's not a conviction. And so regardless of what tool we want to use, we got to follow the Constitution. We have to follow the law. Despite what our new president is talking about doing, there's law that you have to follow. And so if you follow that law, that conviction, or I strike that, those 7 arrests are irrelevant because the person was never convicted. And for a whole host of reasons, maybe he wasn't the person. Maybe he had a problem with the officer and he mouthed off and got arrested. Maybe, in fact, the evidence, if any evidence was taken from him illegally. Or maybe he had a damn good lawyer. Regardless of the reason why it happened and the person has never been convicted. To hold it against that individual is problematic. It's problematic. To ignore it is problematic. What we have to do is come up with, what is the balance? How much weight to give it, if any?
And I guess what I'm asking for is for us to, or the committee, to come up with factors that we know could have those things that Mr. El-Shabazz is talking about, where it could be something that's, important, or it's something that may cause a disproportionality in this risk assessment tool. And then we bring it to the researcher to figure out how do we design a tool that takes into consideration the totality of things that I said as well as Mr. El-Shabazz said. I don't think the fact that someone is arrested is completely ignored, but it doesn't have to be a determining factor in a risk assessment tool. You can use conviction data, and that could get you exactly where you want to be in terms of
And I agree with that
action.
comment, by the way. I agree in total with the comment that it should not be used as an overweighted tool in making a decision. No, if we do that, then we violate the Constitution.
Thank you for sitting in between them. Julie, go ahead.
We're on the same team today, right?
Well, we came to a conclusion.
I mean, a little bit. We're about this close.
To both of their points, I think it's also important to note, not only are we talking about which factors and what weight they would have, but that what the risk tool eventually tells us when the factors are baked in is not the only piece of information we use. There's still room for other information to be gathered, whether it's from a defender or other individuals who can advocate on behalf of the person we're talking about. So it's one piece of a puzzle that we're trying to standardize and trying to figure out how best to standardize, but it's never going to be the end-all be-all decision maker as well.
Mr. Cobb, you haven't spoken, so we're going to go with Mr. Cobb first.
William Cobb, redeemed. I think that we've all had ample amount of time to familiarize ourselves with Professor Burke's long history of selling this tool across our country. I agree that we obviously can't use anything by itself in order to be able to make an accurate predictor of human behavior. But what I offer up is that there is no way of predicting human behavior. I'm listening to everybody offer up these factors that need to be considered, but are woefully neglect in thinking that we should talk or measure the culture of policing in Philadelphia and across our nation, because this doesn't indicate what a person has done. This indicates how the system responds to a particular group of people, whether or not we use their neighborhood, whether or not we use their race. So I just want to conclude this brief statement with saying that let's be mindful that Professor Burke said, quoted, "The policy position that is taken is that it's much more dangerous to release Darth Vader than it is to incarcerate Luke Skywalker." If this commission was charged with dismantling the prison pipeline, then what we're considering does absolutely nothing than offer a bend in that pipeline. We are not taking into consideration that the reason that we're reforming our criminal justice system is because people in black and brown communities have been a victim of a system. So the goal and objective is to increase public safety, but is to stop victimizing particular communities based upon their race, their class, and their income. We are not yet where we need to be as a committee and really take into consideration why we're here and if we need to be doing these things. Communities are being ravaged because behavior is hyper-criminalized, because communities are being over-policed, and yet we're here offering solutions that may not be accurate, but are going to have an incredibly detrimental, or continue to have an incredibly detrimental impact on individuals' lives. So it's great that we're talking about pre-entry, but we haven't taken the opportunity to address post-re-entry. So there's some opportunities that still lie before this committee, and before we make investments, or before we offer up something to City Council to this degree, I would suggest that we pause, that we take greater measure of what it is that we're going to recommend, and do a better job of thinking about the fact that this committee was put together, or part of the reason, or a part of the mission, was to dismantle the prison pipeline.
I don't know if that was the mission I got.
Wasn't the mission I got either.
Wait, let me finish. First of all, thank you, because as I said in the beginning, we all have different perspectives on things. We all sit in different seats. We all live in different neighborhoods. We all have different experiences that we're bringing to this committee. And what we hope to do is not have a perfect document, but have a general direction in which we're not going to get it all right. But what I hope that we are able to do, and I appreciate your comments. I appreciated your comments up at the prison. I really listened to them. But what we have to balance, and now I'm going to use that word again, balance, is the fact that there are folk at home, many of them live in my district, that don't agree with any of us. They have been victims of crime, and they don't want to hear about dismantling anything. They don't want to hear about, and I'm telling you, I've met them in my barbershop and in my grocery store. And they say, yeah, I saw what you were talking about and blah, 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 blah. I said, but my son was murdered. And he ain't never coming home. And you need to balance that. And that's why the beauty of this configuration of individuals, the Justice League, we've called it, is the fact that we have to take all of those perspectives into account and to try to come up with a reform. And that's the key word in here that I look at. That we know we don't have it right. We know we don't have it right. But how we get the better, and then hopefully the best, is a slow, methodical process.
Right. I agree with you, Councilman Jones, and William Cobb, I do not disagree with what you're saying, but one, I disagree with this. This committee is charged with the task of looking at our system piece, frame by frame, and right now we're on the frame of what are we doing with pre-entry. Who is coming into our system to begin with, and how can we do or create reform efforts to understand what we should be doing with people. So this is a large, complex system, and it's not going to take, it could take years to dissect all of the areas of practice, but you want to make sure you're looking at the distinct areas that can make a huge difference. One of the things that our committee wants to do is not make people more desperate by our criminal justice policies and practices, because that does not achieve public safety. At the end of the day, it does not. When you put people in on a pretrial incarceration status where they were not a threat to public safety, or they had no ability to flee, then you're taking away, one, their ability to live and also keep employment, keep up with family obligations and situations. You're kind of destroying that mechanism if we don't do this more mindfully as to who we're bringing in and who we're giving an opportunity to be released into their community, so that they don't lose so many valuable things, and at the end of the ordeal come out of the system worse than they came in. And I think that we have to go through this in a step-by-step process. And at each process, we are looking at areas in which we do not want to create the disproportionality that you are talking about. That's why we are talking about it in a fashion that we're going to explore the opportunity to use risk assessment tools, because it seems to be a uniform way to understand who we're bringing in and who we're not, and why. But I would be remiss if I did not say this. The Defender Association of Philadelphia is including in the pretrial process the use of bail advocates. That will increase the ability to gather more information about an individual, so that it will offset any decision made based on the tools analysis. And we're doing this as a pilot program, but we will be able to see the effects of that, because we're doing it in some areas and we're not doing it in others. We have bail hearings that go on 24/7 in the city of Philadelphia. We are going to be using bail advocates in a certain portion of the day, and we will not be using them in others. So we'll be able to study the effects of those things, and did we make smart decisions based on that. But I would not say to you that's the end-all be-all. Because we're looking at the opportunity to use risk assessments, we then have to make sure we put in the opportunity to review how are they working for us. Are people being released and committing more crimes, or are people being held where they had other factors that should have been included in those determinations? So we have to make sure that we review everything that we do, and I think that we have to move the needle. If we paused, we will never get anything done. We have to build the basic infrastructure to create and collaborate on some of the things that we're doing.
One of the most interesting things about this environment, this committee, this collection of individuals that have different thought processes and come from different experiences, is that you have extremes. You have extremes of people that destroy everything, blow it all up. It doesn't matter what anybody ever did. Don't ever put them in jail. And you have the individual that doesn't matter what anyone is accused of, keep them in jail. But the beauty of it is that through the extremes, just like a diamond from the pressure of coal being pushed on all of the sides, the beauty of the diamond is produced. And so I am not one for throwing the baby out with the bathwater. I am not one for reinventing a wheel. I'm not one for standing on a platform and just yelling about all the things I hate about the system that keeps some people safe. Because everyone has a problem with the system until their mother is murdered. Then there's an issue, or their son is murdered. Then it's an issue. Just like everyone has a problem or don't have any problem with the system until their son is arrested, or their mother is arrested, or in fact they are stopped and arrested. We have those extremes. The only thing that we are charged with doing, based upon my understanding, and my understanding may be incorrect, I'm not the most intelligent person to ever exist on the planet Earth, but I'm by no stretch of the imagination.
Probably the second.
but by no stretch of the imagination, any tool short. So what I'm submitting to you is that there is a conglomeration of everything that we're talking about. There are some things that Mr. Cobb is saying that I agree with wholeheartedly. There's absolutely an industrial prison complex. There absolutely was a design to fill those prisons up. It absolutely was done in rural counties where no longer you could use coal or you can use steel, and there was a depressed economy there. It was absolutely put in there that every family member works in the prison, whether they're a doctor, a lawyer, a doctor, a mechanic, a cook, or a prison guard. Those things were done. To ignore that is to ignore the truth, and nobody's running from that. I'm certainly not running from that. However, there are people that are in that prison complex that I'm glad they're there. There are people that are in that prison complex that shouldn't be there. And there are people that are in that prison complex that are in there longer than they should be. That's the reality of it. It is my hope and my desire in putting forth our platforms and putting forth our position. For anyone to sit here and say that they don't have a position that they're putting forth, they're being disingenuous. We all are putting forth our platforms. But in putting forth our platforms, what we should be clear about is that the eye of the needle, the goal, and it's just as small as that needle, the goal is to come up with a fair, a just system with integrity that would evaluate what is going on and make a determination whether or not you can be safe, you can be secure, and you can be treated right, you can be treated justly, you can be not falsely accused, you cannot be brutalized to the end of it. And I think that this process is a process that's going in that direction. And just like Ms. Bradford and myself, Bradford Gray, I'm sorry, and myself, Kier and I, just like Kier and I go back and forth as we have this intellectual debate over and over again about what we think may be the best way or how we can manipulate it. It is our hope that in going through this with respect for each other's position, that we can come up with something that is a working tool. And like they always say the Constitution is, as I end, that is a living, breathing document. The criminal justice system should be a living, breathing system that changes when it needs to change, that cuts out the cancer that it needs to cut out from prison industrial complexes, but deals with how to treat each individual justly, correctly, with integrity, with respect, with an eye toward keeping people safe.
I just want to read the mission statement, because individuals indicated that they were unfamiliar with it.
No, I'm just not familiar with that being the only
So
goal.
I'm just going to read it verbatim. The
I just
Special
wanted to be
Committee on
clear.
Criminal Justice Reform.
Yeah, but don't say that that's what I'm saying. I'm not familiar with the mission statement.
Okay. Philadelphia City Council, working in partnership with the community and stakeholders to improve our criminal justice system, dismantle the pipeline to prison, and reduce crime and recidivism in Philadelphia. That's our mission.
You named 3 goals. You only talked about 1. So the bottom line is, although it includes that your platform, it also includes mine as well. And that's the beauty of it.
I don't disagree. I'm just indicating that
I got you, bro.
dismantling the prison pipeline is a part of the reason why we're here.
And I'm indicating improving the criminal justice system is one of the reasons that we're here.
And that's why you're all here, because we bring different perspectives. And believe it or not, that's why this configuration is so important. There's no monolithic view of how this world works. And that's in the agitation and back and forth, I think we'll get progress. And that's why it's an honor to be a part of this committee. I kid you not.
First of all, that's my brother. Let's be very clear.
I already know y'all. And brothers argue the worst. You should have seen it in my household. Judge Lerner, and then we'll go this way.
I'm not so good at these statements of totality on one side or the other. But I would say that with regard to the 3 missions, or the 3 parts of the mission of this commission, as set forth in the resolution, which was just read to us again, the decision about who should be in custody pre-trial and who shouldn't is a decision that affects all 3 of the portions of that mission statement.
Yes.
And just as Mr. El Shabazz said, with regard to people who are in our prisons. There are people who are arrested and charged with an offense who should not be in custody pretrial. There are people who are arrested and charged with an offense who, notwithstanding their presumption of innocence for that offense, should be in custody pretrial. And there are people who are arrested and charged with an offense who should not be in custody pretrial, providing that we can take certain steps to reduce the risk that they presently present with regard to public safety or failure to appear without keeping them locked up. And the question is, once we finish all of this, all of the overarching discussion, is how do we decide? Now, it's easy to say, because it's accurate, that nobody can predict individual human behavior. That statement is, for our purposes, as irrelevant as it is true, because we have to decide, we have a system that has to decide among those arrested who is going to be in custody pretrial and who's not. And in making that decision, we are, to the limited extent of human ability, making some predictions about the likelihood of human behavior in the future, at least that person's behavior in the future. Otherwise, we could just flip a coin. Your heads, you're out, your tails, you're in. So it seems to me that what we really have to deal with is, what are the best resources we have for making the most reliable determinations in what is ultimately something for which no assurance is possible. I've done a lot of bail reduction hearings in a lot of cases in my life. I've done them as a defense lawyer, and I've done them as a judge. And to me, the most important element in assuring a fair determination by a magistrate, commissioner, judge, whatever you want to call the person, who has the power to decide, is information, accurate information. And in our system, that information comes through effective advocacy. That's why, in my view, of all of the steps called for in the MacArthur grant, for me, the single most important is the development of a bail advocacy system by the Defender Association, which ultimately will give a determiner of in or out all of the relevant information that can be obtained about a defendant's background. Because we already have the ability on the part of the district attorney's office, although I know we need more resources to enhance that ability, to provide the other side of the picture. And that, it seems to me, is what we ought to be looking at. What are the tools that will help the advocacy process be most effective, most powerful, and most accurate for each side in providing the person who's got to make the determination with the most information in the most accurate way? Let me just, as one example, use this arrest issue. If I'm arrested in Rittenhouse Square because I'm carrying a loaded 9mm, and I don't have a license to carry. I go to trial, but I don't go to trial because I win that case on a motion to suppress. Tariq is arrested outside the DA's office. Well, no, maybe in Councilman Jones' neighborhood. In Councilman Jones' neighborhood. He's also charged with carrying a gun illegally. Although in your case it might not be illegal. But let's just assume for a second you don't have a license to carry. He goes to trial. And his defense is, that gun wasn't mine. It was in the car that I was in. But it wasn't my gun. He goes to trial, that's the defense, and he's acquitted. Well, in his case, if he's arrested again, that arrest should mean absolutely nothing. In my case, I would submit to you, if I'm arrested again, it does mean something. And that's the kind of information, the distinction between what those two arrests were all about, that ought to be provided by advocates to a person who's making the determination as to what extent somebody's arrest record has to do with what bail ought to be or their conditions of release ought to be. These are very, very specific issues. And I suggest that, except in the most general terms, they need to be handled as specific issues involving specific sets of facts provided effectively to a decision maker by effective advocates. And if we can do that,
Right.
and if we can use whatever instruments will help us do that without overemphasizing the effect of one instrument over another or one issue over another, we'll go a long way towards improving the criminal justice system and putting a lot of roadblocks in that pipeline.
Can I just speak really quickly to that? I think that's exactly what we're talking about. Not having it baked in a risk assessment tool, but using it as a separate piece of advocacy. There's nothing that stops the DAs from saying, Your Honor, this person has had multiple arrests for this, but the only reason they haven't been convicted is because the witnesses, for some reason, keep failing to show up. That's not in an assessment tool. That is used for the advocates to provide other additional information that's outside of that tool. When we start baking it into a tool, it bakes in that inherent bias that we're talking about. So we should stay away from arrest data from a tool's perspective, but that doesn't mean we can't bring it in an advocate, from an advocate standpoint. I'm just talking about making sure we have a tool, if we're going to use a tool, because remember, tools take out the humanizing factors of our system, and that's why we got into this situation to begin with, because our humanization of people have diminished to a process. And so we're trying to make sure that we don't over-account for one thing in a tool where it could have different meanings attached. And where it does have different meanings attached, advocates will do their job and provide that information to a decision maker as to what meaning they should place on that. But I would submit to this committee that we need to have a tool that is as bias-free as we can get it, and not rely on someone's opinion that it will be less accurate, because this should not be just the end-all be-all of our determination. We have to understand, how is this working out later? And when we set up those practices that they were set up in other jurisdictions that have a successful model, where they have a review period every 2 years to figure out, do we need to adjust here or do we need to adjust there? That's when the real information will come. But we need to provide the infrastructure to start. And I would just submit to the committee to create a tool that has not, the glaring stuff is already there. zip codes and race. Yes, when you see zip codes and race, you know automatically that's going to have some bias in it. But the other things that we're talking about, like policing strategies in certain neighborhoods, we need to have that be mindful of that. So when we're talking to a developer about what tool they're going to develop for us, we can ask them to take out arrest data as a risk factor, maybe put in conviction data. I don't even know if that will, and I know, William, that is a little inaccurate too. And I want to make sure that we keep this fundamental concept. Pretrial, a better use of pretrial practices does give us more accurate results in the end, because a lot of issues with pretrial detention result in sometimes forced pleas, where people are pleading to bargain for their freedom. That does happen a lot. People find themselves in situations where they're sitting in custody pretrial, and they end up pleading guilty based on the fact that they no longer want to sit. That does happen in a portion of cases. It is true that people plead guilty because they are guilty. I get it. The one thing we have to remain is balance, and we can't have an extreme position on either side. Every criminal justice evolution is about being flexible, examining your own practices, examining yourself, and figuring out how do we move from this standpoint to a different standpoint where we evaluate the effects of that on mass incarceration and disproportionality in our system while achieving true public safety. And we can't incarcerate our way to public safety. So we've got to do a better job at it.
You had a comment?
And next time my wife says I talk too much, I said you should come to one of these meetings.
Yes, she should.
Anyway, I want to get back to the original arrest. One of the problems that I saw working in the prison system for 24 plus years is that once you get that initial arrest, it's like quicksand. Those detainees will continue to pull you back and back. You can get arrested for not paying the fine. You didn't pay the fine, you can go to jail. You can get arrested for being out too late at night. There are a number of factors that they put these conditions on you, the probation and the parole department, where they can violate you. You're reprocessed through the system again. You go back to jail, and those things will probably be showing up as arrests when in fact they were violations, be they technical violations or be they direct violations. The other thing is that when you look, I used to sit on the inmate disciplinary board, and there's a lot of crimes that are committed by incarcerated people right inside the prison. They're a lot of times not reported, like stabbing an officer. There's a report that is issued, sometimes there's no arrest. And I think that we have to, when I was a social work supervisor, I would sign off on reports to the judges. They were called parole adjustment summaries. That parole adjustment summary had a detailed account of the inmates' work, education, and the inmates' infractions, disciplinary infractions within the actual prison system. That then went to the judge, and they would determine whether or not this individual was eligible to be paroled based on that report. I think that we should also look at that when making these decisions, because if someone is incarcerated and are practicing that same behavior, where they're stabbing a guard or they're smuggling drugs in, that should weigh more than these arrests that are actually violations of probation or parole.
I think maybe they would if, in fact, during the time that you're making a bail decision, you had at your disposal all of that information. There's a lot of information that people don't have, and in fact, there's been suggestions made by the committee to get more information, to give more information to the magistrate or bail commissioner or judge that's making the decision, and to use that information as a basis as to whether or not someone should get pretrial release to the end of it. So the difficulty is, although that is absolutely excellent information and vital information that any magistrate would welcome, question is, how do you get it in that short period of time when someone is arrested? Now, hopefully, leaving the area of the techno-taught era, we will be in a situation where we be able to pull that up through the information that we have at our disposal through computers and networks to the end of it. If we don't, then unfortunately, at that initial stage, in terms of bail, we won't have the ability to get that information. But any information, and I think that the judge and Keir both kind of touched on it, any information that we can gather to give us some insight into that individual is good information. If it shows the type of individual that that person is, because it allows you to make some type of intelligent decision that's not based upon opinion or based upon a bias, hopefully, but based upon the evidence that you're receiving at that time.
Ms. Schwartzman?
Thank you.
You done?
Yeah.
Ms. Schwartzman?
Just briefly, this is the information age, and it's great. We can use technology. There are all kinds of possibilities with good tools, things that we can use. And just as you had mentioned on the panel, it needs to be just part of the package. But at the turn of the century, we had something called phrenology, where people came out saying that the way to investigate whether or not a person is going to act out or be a criminal or do additional offenses was by the number of lumps on his head. We've come a long way from that, but the point is, there's no one magic way to do it, because we're all human, everything changes, nobody really knows. But we have to work towards it, because there is inherent bias right now, and it's not good enough, and I think we all recognize that. So to work towards something that does include as much information as possible in a way that can constantly revamp, recheck, evaluate, so that everyone can really think through, is this doing what we need to do, is the way to go.
So why don't you do it?
And I think that's built in not just to the recommendations we're talking about here, but the majority, if not all, the reforms that we're currently pursuing. We need to constantly look at what we're doing. That's why several of them are only pilots and not full-scale rollouts, because if we don't know whether or not something's going to work, it's more prudent to make that small investment and test it out first, then expand it if it's effective. And so that's true for the bail advocates. That's true for some other programs not mentioned here, like our pre-arrest diversion pilot that'll be rolling out next year. And it's true for whatever tools we decide to use in decision-making going forward. We need to continually evaluate, recalibrate, and as was previously said, this is a living, breathing system with people in it. Things change, factors change, and we'll need to continually account for that.
You done? Thank you. Chair recognizes Mr. Cobb. He has a time constraint and wants to cast his vote now, and I'm going to recognize him so that we will have an official quorum when we do. Mr. Cobb.
William Cobb, and for the record, I vote nay for the recommendations as put forth today.
Thank you, Mr. Cobb, for your input, and we do really sincerely appreciate it. It gives us perspective and balance. Thank you. All right, no further questions for that item. Mr. Shabazz, I understand you're going to bring up the issue of day reporting centers.
That's correct. The committee come together and recommended, the fourth recommendation is that the city should conduct a study on the feasibility of opening 3 day reporting centers by fiscal year 19 that will offer services to pretrial defendants as an alternative to pretrial incarceration. And this is something that CJAP is looking forward to as well. There's in fact a subcommittee on CJAP that's headed by the District Attorney, Seth Williams, to explore the actual implication of day reporting centers. Now, it's important to say that when we talk about day reporting centers, we're talking about the centers that could be utilized for nonviolent and low-level offenders who would otherwise have been incarcerated because the amount of bail that they had would not be able to afford to do that while awaiting for trial. It would be a place that they would check into. And the most important aspect of the day reporting centers that we're talking about is that which was spoken to by Judge Lerner, and that is the services of community-based treatment can be based in that area. It's a center that we may be able to set up drug treatment programs. We may be able to set up counseling, even job counseling. We may be able to set up some type of mental health services. So we would be able to actually deal with those aspects. The person has to report to the day reporting center, and as part of them reporting to that center, they have to avail themselves of one of those treatments that an assessment would show would be beneficial to them, so that we wouldn't see them again. Maybe we can get rid of this particular case. These resources, I think, will be very, very important to not only that individuals, but to the production of the individual in society. They would be opening 3 centers in 3 different areas, and the committee would be charged with specific cost analysis as to these centers. And I said that with a smile on my face because I want Councilman Jones to make sure that he mentions to his colleagues that they can be one of the individuals that vies for a center being opened in their section.
Mr. Shabazz, I'm sure they'll be lining up.
I know one is going to be in the 4th Councilmanic District. And it should include visits to other jurisdictions that already have these type of services implemented and try to determine how these programs are successful. So we should do an analysis of day reported services in successful jurisdiction and figure out how they are successful, and then more importantly, try to make their success applicable to the surrounding circumstances in Philadelphia. Philadelphia is a different type of county, a different type of city, a different type of animal. So we need to be able to adapt whatever we see from other jurisdictions that have successful day reporting centers into those things that will address the needs of people in our community. They need to concern themselves, and this is the special committee that's appointed to assess this. They need to consider and review the data concerning the daily costs and the recidivism rate of crime in those areas where day reporting centers are used. This will give us empirical data. And it's always important to have numbers and to look at things, especially when we're talking about asking people to finance. What is the success rate of it? Does it really work? Is it something that sounds cute, but it actually doesn't do anything for recidivism, it doesn't do anything for rehabilitation, it doesn't do anything for the pre-entry because it becomes a post-entry afterwards. At the end of this feasibility study, a report concluding the findings of the study should be issued to Council of the City of Philadelphia. The report should include the city-based plan for the operations of these centers within all 3 selected districts and serviced individuals who would come from and where the districts would be, and identify those particular services that they can have. In other words, we have to determine where they're going to be, what are the costs, and the cost of servicing them. It doesn't make sense to have 3-day reporting centers if we're not able to service them with people for rehabilitation with respect to drugs, with respect to alcohol, respect to mental health, respect to even career and job placement. Some of those things are the result of people being arrested for things that are nonviolent and non-serious or low-level offenses. So they would have to look at that in that regard. But there's an important aspect of day reporting, and I want to read it specifically from this recommendation. The report should also include the strategies to develop a good neighborhood policy. A good neighbor policy. There are going to be pushback. That people are going to say, I don't want these day reporting centers in our neighborhood, which is interesting to me because if someone lives in that particular neighborhood, they're able to make bail, they will be back in the neighborhood. At least in the day reporting center, we will have, first of all, a check and balance system, and they have a place to check in addition to seeing that these individuals are receiving the services that we believe they need and that may prevent them from even ever entering in the criminal justice system. We also would like the committee's report to include for the communities to interact with the development of that particular good neighbor policy and the implementation of any day reporting center within the city in order to alleviate any fear or concern that the public may have. Now, we're going to get that. There are going to be people, whenever someone talks about when they move the juvenile justice system or the youth study center, if you will, there were complaints about where it would be. If someone puts a halfway house or a rehab center or anything that centers around crime in particular neighborhoods, there are pushback. But that pushback can be addressed if the committee does 3 things. 1, they have to take a census of the community or the district that they want to put this program in or this day reporting center. 2, they have to intelligently advise the community of what this center is. What will it do? What type of people will come to this particular center? How, in fact, will the center be supported? What type of security devices or security strategies that are in place to ensure that they don't have to be concerned about whether or not somebody's going to come into their neighborhood and do anything. It is important that when we do a project like a day reporting center, that we do it not in a vacuum, but we do it with community support. If we don't do it with community support, it will not be successful. We don't want to go into a situation where the community is not fully advised to what's going on. And lastly, assured that not only will they be protected, but these are individuals from their community that will be serviced. If there is an individual that they know that hangs around a particular corner that is addicted to drugs, to narcotics, and that individual always gives them a little fear because they think that they may break into their car, or they may take their tire, or they may take a piece of brass bar from a union lead. If these individuals know that now this person is being treated for a mental health condition or for drugs and alcohol, being counseled, being offered services, even if it's career services, that seems to me that that would alleviate, and it should alleviate, some of that fear. Because everyone that is accused of a crime, and I would even submit may have been convicted of a crime, doesn't do it because they just want to do it. Sometimes it's out of, unfortunately, the necessity that they believe they have or an addiction that they have. The late Judge Conroy, who was a municipal court judge when I first arrived in Philadelphia, and probably one of the realest judges I've ever met in my life, one with probably a tremendous amount of common sense, said to me as a young assistant district attorney when I got into a rather lively debate with a private attorney who was across the bar from me about an issue of bail. And the judge made a determination as to issue that particular bail to my objection. After the closing of the list, he called me to the side and he said to me, he asked me a question. He said, if in fact you were unemployed and you had 3 babies at home and those babies were hungry, didn't have any money coming in, and had no belief that you could get money or earn money at that particular point to feed the family, which was an immediate need, would you go into a store and shoplift? And then I hesitated because I'm saying to myself as a young assistant, is this a trick question? Maybe I want to answer it correctly, even if I believe something differently. He said, well, let me answer it for you. I would absolutely shoplift. I would shoplift so that I would feed my family. However, is the shoplifter that shoplifts to feed his family, although an illegal action, the same as the shoplifter that shoplifts just because they don't want to work, or they boost because they don't want to work? Sometimes retail theft, although may seem harmless, you go into that person's apartment, they have another store in the apartment of all the retail theft that they've committed and all the clothes that they have. So what he was saying to me is that there are different reasons that put people in different circumstances and as a result of those circumstances, people may do things that ordinarily they would not do. Should that person be held to the same accountability? It's kind of similar to the analogy that Judge Lerner gave us. Well, those are the type of analogies we have to give to people in those districts where they're going to be day reporting centers. We have to humanize people. We have to indicate to people that those individuals, or all individuals that have been arrested, doesn't mean that they're bad individuals. And unless you have a family member that's ever been addicted to drugs, you don't understand the trauma that the family goes through. A mother that watches her son take everything out of her house to sell because he's chasing the crack. So, I'm sorry. Absolutely. I'm sorry. And so, and I'm glad you said that because now it brings me to the conclusion because I forgot the point I was getting ready to make. I really didn't, but I need to conclude. At the end of the day, we believe that this is a prudent recommendation. We believe that the first step in this recommendation is a feasibility study. And that feasibility study should reflect all of the elements and the ingredients that I've read thus far, and those ingredients should be tailored to what are the needs and of the populace of the city and county of Philadelphia. I've had an opportunity prior to returning back to the district attorney's office to try cases in a tremendous amount of counties in the Commonwealth of Pennsylvania. I mean, some that was close to the border of New York, and some that were close to the border of Delaware. And in those particular counties, I've had an opportunity to see a lot of different things. And what I do know, and I believe to be true, is that Philadelphia is a different animal. Different needs, different understanding, a different populace. Only Allegheny County may come close in that type of mentality and understanding. So we need to tailor that to the needs of the individuals in the city and county of Philadelphia, and we need to seriously explore the possibility of implementing the day reporting centers.
Can I say something on behalf of day reporting centers?
I told her she only can speak if it's on behalf of
I
the
will.
recommendation.
I'm on the committee with Seth Williams to explore day reporting centers, and I wholeheartedly agree that this step, one, after we understand how we can implement it with the feasibility study, will be the first step in us gaining the intelligence about who is coming into our system and how we can better address their needs. I appreciate my brother William Cobb's perspective, and I know he has a unique perspective on this committee. But I will say, if we don't engage in different ways to deliver our criminal justice system's resources, we will not ever gather the intelligence to understand what we are doing with people and what we can do differently. And I think day reporting centers are a great way to put the care of the needs of those individuals who have these public health issues, such as mental health and drug addiction, in the hands of professionals that were trained to deal with those situations in a much better way than our prison systems can. And so I really think that the collateral benefits of day reporting centers have yet to be realized. I think that we can utilize community in a unique way for day reporting centers, and I think that we can understand that with a community effort for certain populations, we can do much better than we have been in the past.
Julie, you did a good job. Keeping them up from, but let me just say that I'm couching my words because I'm the only one that has to go before the voters and deal with those words. I support day reporting centers, and I've been to some. I've been to Brooklyn, New York, where Red Hook exists. I've been to Pittsburgh in Allegheny County, where they do a brisk day reporting center with a myriad of programs available to individuals. And I understand there's a really good one in Lancaster, which I hope to get to and be a part of that road trip. But let me say this, that those day reporting centers, I've watched one of my brave colleagues offer a day reporting center, and for political reasons with a small p, she was beset with opposition for months as she tried to assemble the resources. I think we have to take a courageous position, irrespective of politics, and do what is right for everyone. The belief that people are going to return to nowhere is absurd. They return to the zip codes that they came from often, and they can return unsupervised, unassisted, untreated, or we can put things around them, conditions on them that make them three things: a non-safety hazard, that folk are going to operate within safety norms that society puts on them. Second thing is that it's non-disruptive to a neighborhood. So say what you want, I don't want to be next door to an ambulance service, even though I know it does good. But when that ambulance comes screaming out of there, that would wreck my peace and tranquility. So it has to blend in. And then the third thing, it has to be, as you mentioned, a good neighbor. There are ready, willing, and able type places and facilities. There are women's shelters that are in neighborhoods, but for the fact that I know they're there, the neighbors don't know they're there. And when they do realize that they're there, in the case of, I believe in Kenyatta's district, it's ready, willing, and able, these guys go out on snow days and shovel people's snow. They go in alleys in warm weather and cut down those nuisance weed trees. They are good neighbors. And people deserve that. And it's a part, in my opinion, of readjusting back and feeling a part of a community. Because when someone who otherwise may have never, ever been thanked by their neighbor actually gets thanked by their neighbor, you want more of that. You want that gratitude and self-esteem more. So I wanted to say that, Mr. Ross, please take the mic.
Yeah, I just wanted to suggest, if possible, if we can include like a paper to council, we present the document to council on successful reentry centers. And also, if we can arrange for a visit either of this committee, members of this committee to actually go and buttress that report, so when council gets it, they have a document that says, yes, they're successful, they're working, because they're the ones that ultimately are going to have to decide to sell it to their constituents.
Agreed.
And I would suggest, in light of that, that when we address it to council or anyone else, we remind people that we're talking about human beings and that they're not any different from any of us, with the exception of the blessings that we may receive or may have received, or the circumstances that we may have found ourselves in. It is oftentimes distracting, I find, when we discuss issues like this, especially as they relate to public safety, is when we make a distinction between the people that we're talking about and the people that they're going to be neighbors with. The bottom line is, these are Philadelphians. These are people that are born in Philadelphia, or some that transfer or become transplants here, and people that live in these neighborhoods, and that people that had hopes and aspirations as well. Some of them fall victim for a whole host of reasons. And some of them may be problematic, but we're not talking about those individuals. Remember, these are low-level crimes, and these are nonviolent crimes that we're talking about putting in there. And so when we address those, especially with the pushback that I believe that you may get, I'll be here to hold your hand if you like.
I heard you moving in my district to support me anyway. So I'm
well, I don't know if I'm moving in your district, but
See?
because I live in my own district.
okay.
But what I'm saying is, when you address even city council with respect to it, it is oftentimes I find it's better to remind people that we are talking about people. I mean, they kind of are human beings. The son of somebody, the daughter of somebody, sometimes the mother or father of somebody, and the brother or sister of someone. And when you make people reflective that you are talking about human beings, sometimes they reflect on their own family. And oftentimes when they're stating a position, they forget that they have a family member like Uncle John that's at the barbecue every summer and so drunk that you got to put him on a couch, but he wants to be behind a wheel. Or someone who may be addicted to drugs, or someone who made a bad call, a bad decision, and they went to jail. Sometimes when you bring it home, despite people's staunch position, it makes it a little easier.
Opposition.
Are there any questions for our distinguished panelists and participants? Seeing none, thank you very much for your testimony, input, and work. Do we have any other witnesses to testify? Seeing none, going once, going twice, gone. Thank you very much. And now what we'll do is move into you guys can either choose to stay there or come back and join us. Come on.
It depends on what the vote is.
Yeah, well, we'll see. Yeah. Thank you all for your input. It was valuable. So we will now go into our public meeting to consider the actions to be taken today on the interim report under consideration by the Special Committee on Criminal Justice Reform. The chair now recognizes Ms. Bradford Gray for a motion on the interim report for the Special Committee on Criminal Justice Reform as it has been circulated to this committee today.
Thank you, Mr. Chairman. I move that the interim report of the Special Committee entitled A Shift from Reentry to Pre-Entry, as it was considered by this committee today, Monday, November 14, 2016, be issued by this committee to the City Council of Philadelphia with the approved changes.
That was if there were any.
If there were any.
All right. All right, is there a second?
Second.
It has been moved and properly seconded that the interim report of the special committee entitled "A Shift from Reentry to Pre-Entry" as it is considered by this committee today, Monday, November 14, 2016, be issued by this committee to the City Council of the City of Philadelphia. And all those in favor will say aye.
Aye.
All those opposed will say nay. For the record, Mr. Cobb was one, and then Mr. McSorley abstained because of his job with the city. So the ayes have it. The motion carries. The report will be issued to City Council at its next session of council, November 17th, 2016. Before I conclude, I want to thank the committee members for their excellent year of service. And we look forward to continuing to ensure the city implements the best practices in criminal justice reform efforts for 2017. Let me just say that this is in time to start the budget process. That's why there was a urgency of time, because you can make recommendations, and I want to put on the record, I want to thank President Clark. President Clark had the foresight to say that this was an important issue and put together a interesting group, I'll say it again, interesting group of criminal justice professionals, community advocates, people who have been incarcerated, people in law enforcement, defenders, prosecutors, judges alike, to ponder this issue. And I think it's a beginning of a good piece of work. And with that, are there any other comments from the committee members? No. With that, this concludes the business of this special committee of criminal justice reform. And today, I'll thank you. We will recess to the call of the chair. Thank you. Y'all were entertaining too.